Good morning, everyone, and welcome to today's webinar. I am so sorry we're a couple of minutes late. We've had a few technical issues this morning, but we are all good to go now. So welcome to today's webinar on HR and employment law trends for 2025. Let's get going. So my name's Amy. I am Head of Brand here at MorePay, and I will be your host along with the lovely Carl. So we will just get going with the agenda for today. So as you know, we'll be having a little look at trends for the year ahead. We'll be talking about new legislation and the regulatory changes that you'll need to know. We'll be having a little look at recent case law and its impact on HR. And of course, we'll be looking at some upcoming bills and what's on the horizon. As normal, we will do our usual Q&A with our lovely expert, Carl. So I will just share how you can ask a question. So you can do that using the GoToWebinar question panel, which hopefully you can see there. Please ask as many questions as possible. Obviously, it's our favourite part of the webinar. Anything that we can't get to, we apologise and we may be able to follow up with. But yeah, we'll try and get to as many questions as we can. So a little bit about MorePay. We promise to make payroll and HR easy. We've been around for a wee while now. We've also got some wonderful award-winning software, which I'll talk about in a second. And yes, we are highly trusted. You've hopefully seen our Trustpilot reviews. We've got more than 1,400 now. I think a bit more than that. We need to update this, and we are rated excellent. We promise to make payroll and HR easy with our wonderful easy software, our quality services delivered by our experts, and all of this means worry-free compliance for you and your business. As mentioned, we've won a few awards over the years, which we're very, very proud of. So not only for our payroll service, but also for our HR and payroll software. We've also been a finalist a few times last year. And yes, we're very proud of our offering in the industry. Enough about us. I know we're desperate to get to the topic today, so let's meet Carl. So Carl is one of our brilliant employment law advisors. He's also been running webinars for a while now, and is one of our brilliant experts who will be talking about the topic today. So I'm going to stop talking and I'm going to introduce you to Carl. Carl, good morning. How are you?
Good. I'm absolutely fine, thank you. And yourself, Amy?
I'm not bad, apart from a little bit of a stressful start to this webinar. I'm very, very good, Carl. Thank you.
It's all good. It's all good.
Should we get going?
I think we should. First of all, welcome. Second of all, I want to wish you a happy January. But this webinar that we're going to see is in two parts. The first part is things that have happened. Oh God, I'm showing my hands. I should sit on my hands. I know it's annoying. The first part of the webinar is we're going to look at things that have happened recently. And when I say recently, in legal circles, that's in the last year. I appreciate for people in the real world, that's in the last 24 hours. And then the second half of the webinar is the important bit. This coming legislation is the biggest thing that's hit us for a generation. Okay, I'll come on to it. I'll gladly come on to it. But what I want to say is we don't know. We're 80% there. But as things develop over the next 18 months, no doubt there'll be future webinars. No doubt there'll be future updates on free resource that MorePay provides. But what we've got is a heck of a train coming down the track. But anyway, so we'll look at things that happened last year, and we'll look at things that happens next year and the year after. But what you need to do as a business is to get ready. Okay, Amy, could we have the next slide, please?
We can indeed.
Okay. Right. I'm not going to get political because here at MorePay we never are political. The Conservative government has gone. The Labour government has got in. And what we're going to do is see a shift towards employee rights and employer rights. I appreciate there's lots of people on the webinar now that are employers. You can work out if it's good or bad news yourself. I don't have an opinion, but there's going to be a greater focus on employee rights and not employment rights. Right, okay, a growing shift towards employment rights. before we move on, I'm keen to emphasise that there's a lot of data on these slides, and that's the reason that these are downloadable. I'm not going to bore, well, I am going to bore you. The reason I'm going to bore you is because it's vitally important for your business. These are coming down the track. You have no choice in this. It is government legislation. We don't know exactly what that is, but it's coming down the track. So believe me, you need to prepare for what's coming in the next 6, 12, 18 months. Okay, you'll see I've talked about the column on the left, the focus on flexible working and the stronger enforcement on compliance. But let's move on. I appreciate we've got a lot to get through today, so please download this pack because I'm not going to go through everything. Time does not allow it. What I'd like to see is you use this for something to stick on your hard drive to come back to later. It's complex and it's coming. Okay. All right. New legislation. Okay. Let's kick on for the old stuff. The first thing we're going to look at, and let me see if I can get a full screen. Not sure that I can. Yep, it's the carers. This has been in place now for a little while, and again, I'm not going to talk about dates because I am aware when I talk about dates, people just kind of blank out. But this is unpaid care time for somebody that's close to them that is considered to have an illness or an injury that's long term. The key is from this slide, it's unpaid. So what we found here at MorePay is that it's very unpopular because once you mention the word unpay, then what you do get is a lot of people saying, well, I'll sort something out myself. So that's the unpaid carers leave. I appreciate I'm talking really quickly. The reason for that is we've a lot to get through. I mentioned previously, download the slide deck. If I don't hit time, Amy, well,
yeah.
she can hit hard. That's all I'm saying. So I'm scared. So we need to whiz on because I want to get to the 2025, 26, 27 stuff before before I get a headlock. Okay. Again, the paternity leave has slightly changed in April 24. I don't want to spend too much time on this. The reason why is you get a week or 2 weeks in week blocks, but that changed in April 24. And again, there's a lot of detail on that slide, and it's there for your viewing. So please download. And again, I'm keen for the Q&A session at the end of it. Next one is the protection from redundancy. Pregnancy and the Family Leave Act came in April last year. And basically, what used to happen is if somebody went off on mat leave, maternity leave, then when they came back, they were a normal employee. That is not the case anymore. If you go on mat leave and come back, you are protected for a long, long while. That came in April last year, and it extends the protection from redundancy. Now, there's a few questions here, and if I can spend a little bit of time. What happens if your business shuts? What happens if you lose a major contract? Just saying we're going to protect maternity returners is a little bit innocent because it's always a little bit more complex than that. Now, what I want to say at this point, if you have got an issue, please call the MorePay advice line. We run 24/7, 365, and we genuinely want to help. Okay, so if you have a situation where you've got somebody that's pregnant and somebody that's returned from maternity leave, they have additional um, rights. They've always had rights, but they've now got additional rights um, that they are protected for a prolonged period. But give us a call. All right. Thank you, Amy. Shared parental leave. This is a good one. I'm going to sound slightly sexist now. It's not often that we see this. Well, that's not true. What we do see is quite a few teachers that share parental leave. Why teachers? And this is anecdotal, by the way, so don't put a lot on this. A female teacher, and yes, I am aware that women and men can give birth. It's a modern world, but a teacher would give birth, have the mat leave, the 6 week holiday would come up, and they'd flip their parental leave. So the school shut, they get full pay for 6 weeks, and guess what? At the end of those 6 weeks, they'd flip it back. So it's not often something that we see, but it has come in. It is perfectly possible for an employer to flip the parental leave. It can be quite complex because all of a sudden your organization is going to be having to talk to another organization that employs the husband, the wife, the girlfriend, the boyfriend, whatever. But that's come in, something you should be aware of. I'm sure you are, but that's where we are, and that's come in, and that's totally enforceable. Okay, Amy. Flexible working. It's got a lot more tighter. What used to happen is somebody applied for flexible working, and you could boot it 3 months down the path. You could have the meeting, and you could give them reasons why it's not possible for the business. That's now flipped over, where they can still give flexible working request. It's come down to 2 months, but the issue is the proof has been reversed out. So all of a sudden, rather than the employer or the employee saying, I want it, it's now flipped over to the employer saying, you can't have it, and here's the reasons why. There's 8 reasons, and I won't bore you with them. You could refuse a flexible working a request, but uh, they're the same, but the emphasis has switched. Before you used to say, well, have you got a child? Have you got. Now you can put in a request because you want to play golf on a Friday afternoon. Um, they can't push back at that, okay, your employees. So that's changed last year. And again, in legal circles, last year may seem to you like a long time ago. In legal circles, it's last minute. The world. Now and again, I get some training, and I've had some of it in. Well, there's no nice way to put this, but I've had this in foreign language. Uh, anyway, it's not about me. Right, let's move on. All right. Um, I won't use any Latin in this slide, but what's come in is the Worker Protection Act. It's all about sexual harassment, racial harassment, etc. So if you've got employees that are even colleague facing or customer facing, you have to now legally provide some kind of provision that you've demonstrated that you're going to support them, train them, help them in being safe at work from, let's say, sexual harassment. So this slide is 2 slides. The first slide as you can see, gives you some detail on what it is, but you have a legal obligation since last year to provide a safe working environment for all of your staff. Now, I've got some problems here. If you, and we've got a lot of clients that are in hospitality, if you have a bar, okay, and you employ bar staff, male, female, gender fluid, whatever, how do you stop a customer coming in and doing or saying something that's sexually harassing, physically or even verbally? So that's come in, and that's very important. So if you're in a care home, how do you stop a mature person that's a resident abusing a member of your staff? As I mentioned, if you're in hospitality, how do you stop a stranger walking into the bar or restaurant or whatever and abusing a member of your staff? So if we could move on to the next slide. There are some examples of what you need to do, and it's all about prevention. If an employee leaves because they have been sexually abused, and there's no nice way to say that, by the way. I can't work in an environment where I'm open to sexual abuse. Okay, let's stick with the bar staff analogy. They'll go to tribunal and say my employer did not provide me with a safe working environment. You may say, as an employer, then what more could I have done? Well, there's things on that list that the judge will look at. And the important thing is if you can't demonstrate any of that or some of that or all of that, a tribunal may lift the award by up to 25%. So it's keen you put the footwork in training your staff, putting in risk assessments, and it's not a health and safety thing. When I hear the words risk assessment, I automatically assume health and safety, and that's wrong. But you need to work out where the touch points are, and that's the wrong phrase. I do apologise. But what training, what development, what can you do to demonstrate before a judge that you've done all that you can? And again, I'm not going to read out that slide because that's what today is not about, but please download them and have a good look at them because they're a useful reference point. Okay. All right. Some new payroll rates for 25-26. Thank you, Amy. If we could just slide on. National minimum wage has been severely moved up. Again, I'm not getting political, but our Labour government have decided national minimum wage is not enough. Let me show you the over 21s, which is the heavy blue bar at the top. National minimum wage is now, for somebody that works 40 hours a week, in excess of £25,000 a year. And while I'm on this slide, I want to point out that not only are they on £25,000 a year, which is great, as an employer, you've got extra NIC, but there's always a knock on. And what we say, what we hear and say at Morpay on the advice line is you've got a worker on £13 an hour because national minimum wage is £12 something, so they just want to push them up above that. What you then get is a supervisor that will knock on your door and say they're on £13 an hour. As a supervisor, I'm on £14 an hour. It's not enough. So I'd like £16 an hour. You then get a manager saying on £18 an hour. That's not enough. I want to be on £22 an hour. So what you get is some kind of domino effect. So it's okay to look at the minimum wage going up, but what you can get is some kind of domino effect where it rattles up through your business. And it's important to be aware of that. This is coming in April. And most things do come in April, so it's vital that you're prepared for this. If you take our payroll service, they'll be sending you comms on this. If you don't, you need to be chatting to your payroll people and make sure that we're up to speed on national minimum wage. I know they call it national living wage and things like that, but equally, these are the rules. The younger people have got more, a lot more, but the 21s and over have got in excess of 25k a year. Okay, Amy. Again, I'm conscious of time, so I'm not going to spend too much time on this slide because Amy will come around and beat me up, and that's maybe another webinar for another day, talking about gross misconduct for violence in the workplace. So there's a table. Okay, it's in the pack. Please download it again. It's a useful resource, but I need to move on. Thank you. Okay, case law is incredibly boring unless you're a nerd like me. I'm not going to talk through all these cases. The main one I want to talk about is kind of bottom left, next retail, where a really big case. If you go into next, it's predominantly staffed by women, not exclusively, but predominantly. If you go into a next warehouse, it's predominantly staffed by men. And there was a huge discourse about the warehouse men getting paid more than the warehouse women. And again, I'm oversimplifying it. Their argument was men taking things off shelves and women taking things on and off shelves was kind of equal value. So next, and you'll see at the bottom, quite a few million next have been fined. So please read that slide, but the digest is the next time you go into next, your trousers are going to be £5 more. All right. Okay. So again, can we move on? Oh dear, this is a slide I've been dreading. The reason I've been dreading is we don't know. We've got 80% of the knowledge, but the devil is always in the detail. As I said previously, the Labour government came in on a strong opinion of employment law in the UK. Their manifesto was very strong, and they have announced, and it is that, an employment rights bill. And that is going to significantly change the landscape of employment law. And as I said previously, it's a once in a generation thing, and it's coming. We don't know exactly what. We've got a very good idea, but what's coming, we do not know. So let's crack on.
All right. There we
go. What I want to say is that they are going to look at every single facet of employment law, and what they're going to do is, well, what they've said they're going to do, and who can trust any government, is they're going to take things further. So as you can see, we've got the Equality and Diversity Bill, and that's going to take things further, but we've also got longer term issues. Okay, so this is what's going to come in the next 18 months, but be prepared because they have declared that's not enough. They're going to go further. Okay, if we can just move it on. This is an awful slide, and it's in 3 parts. When I say awful, I didn't mean that. What I meant to say is it's upsetting. Previously, if you have a neonatal issue with a premature baby, then employment law didn't touch it. No time off. You had to take holidays, and you know, it was just an awful, tragic, horrible thing that individuals had to put up with. The government have introduced or will introduce, and again, we don't know the precise details, that you get additional neonatal care if you have a baby that's born premature and needs additional care. What I will say, if we can crack it on to the next slide, it's it's not for an individual, it's for a couple. However, that couple formulates, as long as there's parents, but they will get additional leave and pay for neonatal care. So it's not the mother, the father, or whoever. It's they will get additional care. Okay, if we can just crack onto the third slide. That's there, as you can see. I'm not going to read it out, but what I will say is it's going to come in. We don't know precisely what it's going to look like, but work on the principle. It will be there, and I think it should be there, by the way, and that's my personal opinion and not Morpay's opinion. Fire and rehire. There's two opinions on this. The government has said they're going to end it. Let me give you one opinion. If you dismiss one of your employees, they have a legal responsibility to find new work as soon as possible. They have got to mitigate their own losses. So if you dismiss somebody for whatever reason and they go home, sit on their sofa, watch Netflix for 6 months saying, I will see you in court, the judge will take a rather dim view of that. So a lot of employers do the fire and rehire because it mitigates an employee. So if you have significant financial issues and say, I can't pay you £15 an hour, I can pay you £14 an hour, and the employee says no, dismiss, rehire on £14 an hour, your argument in tribunal would be that we've tried to mitigate as much loss as we could. So that's one argument of the side. The other argument is the P&O argument, where you just dismiss them and try and get them back cheaply. The government has dedicated themselves to stop this practice. Consultation is going to be the biggest thing here. This is what the judges will be looking at in tribunal. So you'll have to go there and say, we couldn't afford £20 an hour. The only thing we could afford was £18 an hour. We did our level best. Here's evidence of our consultation. Then you might be all right. Emphasize the word might, because we don't know how the statute's going to look. An old barrister friend of mine said the politicians put a bat and a ball in a field, and it's the judges work out if they were invented cricket or baseball. So again, the caveat is this is how we think things are going to go, but until we get some kind of firm structure, then again, use Morpay, come back to us. I'm sure Amy will be rejoining the conversation in future webinars about how the legislation is going. These are going to things that are going to come in, and things I've mentioned so far are going to come in late 25, 26, whenever. But get your business ready because they are coming. And if there's one thing I can say is download these slides, please, because it's essential. Okay, 0 hours. Let's zip on before we run out of too much time. Again, in the press, 0 hour contracts are vilified. It's disgraceful, it's disgusting. How can anybody expect to be at the beck and call of their master? Sometimes they work really well. If you if your employees say, well, I want to go and visit somebody, I'm not available next week, or I'd like more hours because I'm coming up to Christmas, and sometimes they work really, really well, but sometimes they don't. So what the government are proposing, emphasise the word proposing, is that if you pick up custom and practice, i.e., I work 20 hours, I work 20 hours the next week, I work 20 hours the week after, I work 20 hours, then all of a sudden it's not a 0 hour contract, it's a 20 hour a week contract. So what they're proposing is um, if there's a pattern to your employee's employment, it will not be 0 hours. What they'll say is you have an obligation for 20 hours. I've given a brief example, and as always, the devil's in the detail. But what they're proposing is not to remove 0 hour contracts. They've said we're going to clean them up. So if there's a pattern in there, then there's a pattern for you, and you've got to oblige that. Not quite sure how that's going to work. Some of my colleagues, or a lot of my colleagues, have scratched our heads about how this is all going to work. Some of it is, oh, yeah, it might work. Some of us is like, there's absolutely no chance. Okay, zipping along, because I'm aware we've got a heavy slide deck today, which is, again, I'm going to say it, let's download it. SSP. The main takeaway from this is it's now going to become effectively not means tested, i.e., they've got to earn money before they qualify for SSP, and also it's going to be a day one right. So, as you're all aware, currently, if you've got a poorly employee, there's 3 waiting days, and that was established to stop the too many beers on a Sunday night, a bit of a hangover on Monday, so I'll call in sick. Well, when these regulations become enforced, and I think they will, and I'm not quite sure how this is going to work, but any employee that phones in Monday and says, I'm not feeling very well, then they get sick pay from day one. That's what's going to happen, and they've clearly indicated this is what's going to happen. So the SSP, the overhaul, is coming down the path. We think it's going to happen late this year, maybe next year, but nevertheless, we're confident that it's going to happen. And who pays the sick pay? Regretfully, it's going to be you. So what you might want to do is have a look at your practices and policies about return to works and things like that, so that you can stop people from not pulling the duvet back on Monday morning. All right, because if they're still in bed on Monday morning thinking they're getting money, then it's a drain on your business. Okay, let's zip to the next slide. This is the biggie. And this is the last slide before we get to the Q&A. Right now, when you phone the advice line, the first thing we do is ask for their name, and I'm sure lots of people out there have called the advice line on many occasions. We ask for the name. That's how we log the cases. They're all logged by employee's name. The very next question is, what's their start date? What's their exact start date? And the reason we ask that, and possibly boring you a little too much now, but I'm aware that it's a heavy slide deck, is we're trying to triage your problem. Okay, we're trying to mitigate your risk to your business. When we ask for the start date, the first thing we want to know is, are they under 2 years? And if they are under 2 years, they've no rights for unfair dismissal. The next question we will ask is, have they got disabilities? Are they pregnant? So we're kind of chasing the problem down. So when you think, why are you asking for a start date? It's because we're trying to stop a claim for unfair dismissal, which is the biggest threat in tribunal. There are more expensive threats, but this is the biggest one: unfair dismissal. Now, the Labour government in their manifesto says we're going to reduce that from 2 years down to zero. And this is what, on the previous slide, I did say there's something that got, we're scratching our head, it'll never work. If it's a day one right to go to tribunal for unfair dismissal, there's two major issues. The first major issue is how the heck is that going to work? The tribunal service is, we're seeing cases that are getting listed 2 years ahead. So if you're reducing 2 years for unfair dismissal down to day one, the tribunal system, unless it gets significant extra funding, is not going to cope. The other issue is you're going to get lots of claims. You interview somebody that doesn't want the job. You employ somebody that doesn't want the job. They turn up on the first day. They sit at the desk and drink a can of lager. You dismiss them on day one after an hour, and all of a sudden they can go to tribunal. And bear in mind, there is no financial barrier to entering tribunal. They can do it themselves. They can do it on their iPhone. And all of a sudden, you have a tribunal case in whenever. Okay. So it'll also stop the claims people. If you are taken to tribunal for somebody that's drunk a can of lager for an hour in employment, they're going to have a 1 day, 2 day, 3 day, 4 day, 5 day hearing in tribunal. You've got legal fees. You've got the hassle of it. You've got your employees that are going to be witness, that are going to be cross-examined. So therefore, the probability is you'll just settle them out of that, and it'll be £1,000 for argument's sake. It's a nuisance claim. Now, that's going to create a culture that you go and work somewhere for half an hour, and all of a sudden you get £1,000. That's not so it's not going to work. I think our politicians have learned from that. So they've created something called, will create, we think, we don't know, something called probation. Right now, probation doesn't mean anything in law. Okay? On many occasions, you can pass probation and be dismissed 5 minutes after. Okay, it's an internal thing. It's got nothing in law. However, it's the bright and good at Morpay think it's going to be 9 months. They're going to put it into law for 9 months. So you've no rights to tribunal for 9 months. Right now, it's 2 years. This will cascade in at some point in the future. I think it's going to be next year, by the way. So effectively, unfair dismissal comes from 2 years down to 9 months. So it's something you've got to be aware of, because previously you could let issues slide. If somebody maybe wasn't performing, if somebody wasn't up to scratch, you had 2 years to sort it. In future, and again, we don't know, and again, please come back to us. Use our free webinar. If you're clients of ours, you'll get lots of resource. If you're not clients of ours, please become clients of ours. We're really nice people, I promise you. And if you never want to be clients of ours, please get independent legal advice. It's important. But in my opinion, this one is the biggie, and that's why it's the last slide on the deck. And I'm looking at the clock